Hello and welcome to ProfDale's Property Video number 38. I'm your host, Dale Whitman. In this video, we're going to talk about the quality of title that has to be conveyed under a contract for the sale of real estate. Now, the first thing we need to know is that in every contract of sale, there's an implied covenant that the title will be marketable. So that's deemed to be in the contract of sale even if it isn't mentioned. Many times the contracts of sale will state that the title is going to be marketable, but even if it doesn't say that, that's considered to be an implied term of the contract. Now, it is possible to vary that by language in the contract itself. One common way of doing that is for the contract to provide for an insurable title instead of a marketable title. And by insurable title, what we mean is a title that a title insurance company is going to be willing to insure. Another possibility is that the contract might call for the title to be both marketable and insurable. Now we'll come back and talk about insurable titles again in a few minutes. But first, let's consider what we mean by a marketable title. The legal definition of a marketable title is, first of all, that it has to be in fee simple absolute. It isn't a fee simple defeasible, it isn't a life estate or a fee tail or some other oddball interest. When people buy real estate, they want fee simple absolute title, and so that's what it has to be in order to be marketable. Second, the title mustn't be subject to any unreasonable risk of litigation. Now, obviously, all titles are potentially subject to some risk of litigation. Anybody can file a lawsuit challenging the title to any piece of land. So what we're saying here is there mustn't be an unreasonable risk that somebody is going to bring a lawsuit affecting the title to this land. Because after all, when people buy real estate, they don't want to buy a lawsuit. Third, the title mustn't be subject to any encumbrances. And by encumbrances, we mean all of those kinds of interests that can attach to a parcel of land. Interests like easements, covenants, liens, leases, mortgages. None of those things must exist. If there are any encumbrances on the title, it won't be considered marketable. Now, there is an exception, in fact, several exceptions, situations in which the title will be considered marketable despite the fact that it might have some encumbrances on it. First of all, if there are items such as encumbrances that the buyer agreed to when they signed the contract, then those items won't make the title unmarketable because the buyer has already accepted them. Second, if there are items such as encumbrances to be paid off at the closing. A good example of that is that in many residential sales, there will be an existing mortgage loan that the seller has placed on the property. But that mortgage loan is going to be paid off by the closing agent, that is the title company or escrow company that's handling the closing, and therefore by the time the title passes to the buyer, that item will be gone. The mortgage will be paid off and released. So that doesn't make the title unmarketable. Now, bear in mind that only works if there's enough money in the closing to pay off the old mortgage. If the property is, as they say, underwater, and there isn't enough money from the purchase that's going to be available to pay off the existing mortgage, then that's an enormous problem because that mortgage will still be there, will make the title unmarketable, and the buyer certainly will not want to take titles subject to it. A third possibility is that there are encumbrances or other matters affecting the title, but they are so minor or so unlikely to be asserted that a reasonable buyer simply wouldn't object to them. For example, some defect in the chain of title 100 years ago, the court might say, is just so minor today, the passage of time has made it essentially irrelevant, even though in theory it could be a cause for an objection or a litigation matter for the title, but it's just not likely to happen, and therefore a reasonable buyer wouldn't object to it, and therefore it doesn't make the title unmarketable. One of the most interesting issues with marketable title is whether title that the seller has obtained not through a chain of deeds, but by adverse possession should be considered to be a marketable title. Now, you know from your previous study of adverse possession that in theory, adverse possession can give and adverse possessor a fee simple absolute title to the land. But nevertheless, the case law is divided as to whether that title is a marketable title or not. The reason is that adverse possession depends on a whole series of facts. You can see in the little graphic down at the lower right side of the screen the facts that have to be shown. That the adverse possession was hostile, exclusive, actual, continuous, open and notorious. All of those things have to be shown. And if the seller says, oh yes, I did all those things and I acquired the title in that way, the buyer might reasonably say, well, how do I know that you did? Do I really want the former owner of the property from whom you took the title away to come back and litigate those things after I have bought the property? I don't think so. So I don't maybe want to buy the property at all. In fact, if you ask yourself, would you buy it, considering the possibility of litigation of those items, I suspect the answer is no, you don't think you probably would. What would you insist upon if you were going to buy the property that somebody claimed to have acquired by adverse possession? Well, probably what you would say is, I need a court to put its stamp of approval on this title. So I'd like to have the seller bring a quiet title action, and I'd like to wait until the court issues a decree stating that all of the elements of adverse possession were satisfied and that the seller does indeed now own the property. Once a court has said that, I feel quite good about buying the property from them, but not until we have that court decree. Now, I promised you that we'd come back and talk a little further about insurable titles. If the contract says that a title is to be insurable, the contract had better define exactly what is meant by that, because the phrase insurable title by itself is terribly vague and open-ended. So what are the things that you might want to put in the contract if it says title is to be insurable? Well, first, you might want to put in the name of the actual title insurance company, the underwriter that is going to issue the title insurance policy. For example, you might say, I want a policy issued by First American Title Company. Second, you might want to specify the type of policy. For example, you might want to say, I want a 2013 American Land Title Association homeowners policy. Now, you might think that's awfully technical, but in reality, when you begin to examine title insurance policies, you discover that some of them are very, very much weaker and others very much stronger in protecting the insured party. So if you want a strong policy, you'd better say so. Third, you might want to say that the policy will be insurable at standard title insurance rates, because many times title insurance companies will take extra risk if they can collect extra money, but maybe those extra risks are things that you as a buyer are not willing to accept. Finally, there is a Schedule B in every title insurance policy that shows the matters that the title company actually found in doing its title search, and those are considered exceptions to coverage. The title company, in effect, is saying, we found these matters and therefore we're not going to insure against them because we know they exist. So in our contract of sale, if we're going to call for insurable title, we probably ought to say what the specific exceptions in Schedule B are that we're willing to accept. One common example would be that we're willing to accept the title subject to the lien of the current year's real estate property taxes. And the reason for that is that in most states, the taxes aren't payable until close to the end of the year. So for most of the year, you really can't avoid taking title subject to the lien of the current year's taxes. That's perfectly acceptable to most buyers because they're going to prorate the cost of those taxes between the buyer and the seller at the closing. But if there are any other matters that the buyer is willing to take as exceptions in Schedule B, they ought to list them in the contract of sale. And otherwise, they ought to say that no exceptions will show in Schedule B if the title is to be considered insurable. Now, many times a printed form contract will have a clause in it that obligates the buyers to accept title subject to a very broad and general statement about the encumbrances that are going to be allowed to exist on it. In this example, the contract says, Purchaser agrees to accept title subject to easements, covenants, and restrictions of record. Now, the problem with that is that at the point at which the contract is signed, the purchasers haven't usually seen a title report on the property yet. They haven't done a title search, and they have no idea what those easements, covenants, and restrictions of record might be. They may turn out to be perfectly innocuous, or on the other hand, they may turn out to be highly objectionable, depending on what they say and on how the purchaser plans to use the property. So it's very unwise for the purchasers to accept the title subject to a vague general statement of this kind. Instead, the purchasers really ought to say to the seller, if you want us to accept your title and it's going to have some encumbrances on it, tell us what they are right now and we'll write those into the contract if we find them acceptable. We're not going to agree to accept the title subject to matters that we've never seen before and have no way of evaluating. Now we're going to talk about some kinds of encumbrances that sometimes the court will say don't make the title unmarketable just because it would be sort of unfair to the seller to let the buyer object to them. The first of that category is matters that are readily visible to the buyer. At the time the buyer signs the contract, let's suppose there's an easement across the property for an open irrigation ditch. And the buyers looked at the property, they saw the ditch, and it doesn't take any genius to figure out that there must be an easement to allow it to exist there. So it seems quite unfair to let the buyer later object to that and get out of the contract because of that easement. A second example is something that, even though it may not be visible, was known to the buyer in fact at the time the contract of sale was signed. For example, there might be an easement for a neighbor's driveway across the property, and the seller, in showing the property to the buyer, or the real estate agent in showing it, called that to the buyer's attention. So even though the buyer might not have otherwise realized that that driveway was on the property that is being purchased, if it's been told to the buyer and the buyer is fully aware of it, again, it seems quite unfair to let the buyer later get out of the contract because of the existence of that encumbrance. A third possibility is that there might be encumbrances, typically easements, that are beneficial to the property. For example, if there's a power line easement across the rear property line, but that's the way electricity is being brought to this property, so that without the easement, the property wouldn't have any electricity at all. Well, that's so beneficial to the property that nobody but a fool would object to it. And again, it seems sort of unreasonable to allow somebody to get out of the contract because of the existence of that easement. Now, these exceptions are not universally recognized by the courts, but they're quite widely recognized. Now let's talk about some items that are very commonly encountered in real estate purchases and see if the courts would consider these matters to make the title unmarketable. The first of them is that there is legal access to the property from a public road or public street, but it is very inconvenient. You can get to the property from the public road system, but you've got to go up a steep grade, perhaps an unpaved road, very narrow, very difficult. In the winter, perhaps difficult to pass by. Does that make the title unmarketable? The answer the courts usually give is no. If there is existing access, then the title is marketable even if the access is very inconvenient. Now, on the other hand, if there is no legal access at all, then the title is unmarketable. For example, if the property is totally landlocked, and the buyer would have to sue to get an easement of necessity in order to get to the property, we're not going to say the title is marketable there because that subjects the buyer to the risk of having to litigate in order to get that easement of necessity. So no access, title's unmarketable. Inconvenient access, the title is marketable. Second example, there's a garage built by the neighbor that's on the property boundary, and it actually encroaches over onto the property that our purchaser is thinking of buying. Does that make the title unmarketable? The answer is yes. Any encroachment, an encroachment from the neighboring property onto this one, or an encroachment from this property onto the neighboring property, will definitely make the title unmarketable, even if it's only an encroachment of a few inches. What if there's an adverse possessor on the property? Is that enough to make the title unmarketable? Yes, the traditional view was that an adverse possessor has sort of captured the season, the right of possession of the property, and therefore the seller, the owner of the property, doesn't really have an unencumbered title to pass on to the purchaser. So that will make the title unmarketable. What if there's an existing judgment lien or a mechanic's lien on the property? Well, that won't make the title unmarketable if it's going to be paid off at the closing, as we talked about a few minutes ago. Just like an existing mortgage, an existing lien can be paid off with money, and therefore it won't make the title unmarketable, assuming, of course, that there is enough money on the closing table being paid by the purchaser to cover the cost of paying off that lien. What about an underground sewer easement across the backyard of the property? Well, there are several possibilities. Suppose that sewer easement serves the house on this lot. Well, the answer then is probably no. Probably a court will say that's beneficial to this property, and therefore, as we talked about on the previous slide, doesn't make the title unmarketable. On the other hand, what if the sewer easement is only serving the house next door? Well, that's no particular benefit to this property, and therefore it would be considered to make the title unmarketable. If the sewer easement serves both the house on this lot and the house next door, it's a debatable issue. What about housing codes, zoning codes, or other municipal ordinances? Do they make the title unmarketable? The answer the courts usually give is no, those aren't title matters at all. They are simply regulatory matters, and they don't affect the title. In other words, you own the land whether the zoning ordinance will allow you to build what you want to build on it or not. However, let's vary the facts a bit. Suppose the seller knows about the code violations or zoning violations, in fact, has been cited by the city for violations of them. The citation, however, is not recorded in the public records, and therefore the buyer can't find it by their title search. The violations are not readily observable by the purchaser. An ordinary purchaser could walk through the property and not realize that those violations exist. In those circumstances, there's another theory available to the purchaser. Even if the court wouldn't find a marketable title issue, the court might still find that the seller, by not disclosing those matters to the purchaser, had engaged in fraudulent concealment. And that, even though it's a difficult theory to prove, can be a very powerful theory for the purchaser. Perhaps in some ways even more powerful than the theory of unmarketable title, as we'll see in a minute. But typically, these matters are not considered title matters and don't make the title unmarketable. What would happen if a purchaser went ahead and closed on the property, accepted a deed, acquired title, and then discovered that there was a big defect in the property's title? Can the purchaser now say, oh, I shouldn't have gone to that closing at all, I want to rescind the sale and get my money back? Well, the answer almost always that the courts give is no. The purchaser is generally limited to damages under the warranties in the deed if they got a deed that contained any warranties of title, but they can no longer sue on the contract of sale after they've accepted a deed. The deed is their sole remedy. Sometimes they use the phrase, the contract of sales provisions about title are merged into the deed. But that's just a way of saying they can't go back and rescind the sale under the contract of sales language about title once they've accepted a deed. However, if the purchaser can prove fraud or fraudulent concealment, generally speaking, the courts will allow the purchaser to rescind the sale and get their money back. So in that way, as I mentioned a few minutes ago, the fraud or fraudulent concealment argument is a powerful argument, more powerful and stronger for the purchaser than the theory of unmarketability of title. So if you're buying real estate and you want to make an objection to the fact that the title is unmarketable, when do you need to make that objection? The answer, of course, is you've got to make it before title passes at the closing, before you accept a deed. Once you accept a deed, you are stuck with the title that you have so far as the contract of sale is concerned. Now, at the closing, as we said a few minutes ago, the contract's covenants of title are, as they say, merged into the deed and can no longer be the basis for a separate suit. However, the contract might expressly state that those covenants survive the closing, and if there's an express statement to that effect, the courts will generally give credence to it. So the purchaser who does want to object to a title defect has got to give the seller notice of the defect before the closing. And if the defect is curable, then they've got to give the seller a reasonable time to cure it. Even if time is of the essence, and even if that would extend the date of closing beyond the date called for in the contract, the purchaser has to give the seller a reasonable time to cure the defect if the defect can be cured. Often, the contracts of sale, particularly printed form contracts, will spell out exactly how much time each party has to give the other. In other words, how early the purchaser has to give the seller notice of the defect, and then how much time after getting that notice the seller has to correct the defect if it is curable. Now, if you're buying real estate, you typically will get a title search done, often several days or maybe even several weeks before the closing date. So if the title search shows that the title is okay from your point of view, should the title searcher then bring the search down to date just before the closing? Well, the answer is they'd better do that literally down to the minute of the closing, because otherwise somebody might record an encumbrance on the title just before the closing, and if you didn't know about it, you'd go ahead and close as the purchaser, and you'd be buying subject to that title defect. There's an existing Washington case, for example, where somebody recorded a judgment lien 9 minutes before the recording of the deed by which the buyer bought the property. And the court said, well, it was recorded before the deed, and therefore that judgment lien is binding on the property, and the buyer has taken subject to it. So you want to make sure that search is brought down to date to the very moment of the closing. And then how soon after the closing should the deed, and if there's a new mortgage be recorded? Well, in the old days, they would often actually do the closings in the courthouse, and they would immediately record just as soon as the closing occurred, again, to make sure that nobody was going to record any encumbrance affecting the title after the closing, but before the recording of the deed. Today, it's not common to do that, but the title companies will cover that. It's called gap insurance, and it means that the title company will ensure that there's nothing on the records that would take priority over the deed that the buyer is getting, even though something might be recorded after the closing, but before the deed is recorded. And even then, the title companies try to minimize that time in various ways to make sure that the recording takes place very quickly after the closing has occurred. Now, one final point we want to talk about for a minute is the effect of a quitclaim deed, if that's what's called for by the contract of sale. Many times contracts of sale will specify whether the deed to be delivered is a quitclaim deed or a warranty deed. And you recall the difference is that a quitclaim deed doesn't make any warranties of title in and of itself, whereas a warranty deed does. It promises that the purchaser, the grantee, is getting good title. So if the contract calls for delivery of a quitclaim deed, does that in any way affect that implied covenant of marketable title in the contract? And the answer is that it does not. The deed and the quality of title are simply separate issues. And even if the deed to be delivered is going to be a quitclaim deed, the implied covenant of marketable title will still be in effect. Likewise, if you do get a quitclaim deed and the title is marketable, will you get marketable title through that quitclaim deed? Sometimes people get the idea that quitclaim deeds are sort of cheesy third-rate deeds, and maybe they don't give very good title. But the answer is a quitclaim deed will pass whatever title the grantor has to the grantee. And so it's entirely possible for a quitclaim deed to pass a marketable title to the grantee if that's what the grantor had. Well, that completes our discussion of marketability of title in video number 38. In our next video, number 39, we'll talk about the time of performance of a real estate sale contract. If you have questions or comments, email ProfDale01@gmail.com. And thanks for watching today.